Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners worldwide who are affected by these issues and want to learn more. Each episode is presented by one of the specialty committees within the section. I'm your host, Anant Raut. Today's episode is part of our ongoing Mergernomics series, produced and co-hosted by the Mergers and Acquisitions Committee, in which we try to demystify the mathematical analyses that enforcers undertake to determine whether a merger will harm competition and should be blocked. In each episode, we bring in a top-flight economist to explain a specific economic test or tool commonly used by antitrust economists to predict the impact of a merger. Today's episode is on bargaining leverage. Joining me today as my co-host is Paula Camara, a partner at the law firm Matthos, Filho, Advogados in Rio de Janeiro, Brazil. Welcome, Paula.
Thank you, Anna. It's a great pleasure to be here. It's my first time ever participating of a podcast, and I could not be happier that my debut is here with you.
Well, we're excited to have you, and welcome to your first podcast. Who do we have on the show today?
We're in the best possible hands today, Anna. It's my pleasure to introduce you to Hélder Vasconcelos. Hélder is a Senior Vice President of Compass Lexecon based in Lisbon and Madrid, and full Professor of Economics at Porto University. He has given expert testimony before several competition authorities and has extensive experience on merger cases. Welcome, Hélder. Bem-vindo. É uma honra dividir o palco com você.
Many thanks, Paula. It's a pleasure to be here. É uma honra também estar contigo.
So, as Anna mentioned, our Mergernomics series is focused on delving into different economic tools that are used in merger analysis, and today's episode will be focused on the bargaining leverage theory. So bargaining is really everywhere and is often used as a synonym for negotiating. So we're usually very familiar with this concept in our daily lives. For instance, when we are negotiating a house we want to buy, or when we're looking for a job and negotiating wages with a potential employer. So in the end, bargaining can also be seen as a way to set prices and terms and conditions. So let's begin first things first. In a very direct way, Hélder, what is the bargaining leverage theory?
Well, this is basically a theory that, in a sense, postulates that when two entities merge, the merged entity gains enhanced negotiation strength, allowing it to influence prices and other terms in its favor.
And why should we care about it in the context of merger cases?
Well, take for instance the case of the vertical merger. I mean, when you have a vertical merger, it's likely that after gaining increased bargaining strength, the merged entity might be willing to increase prices charged to downstream rivals, for example, for inputs as a result of its increased bargaining power, and this is important because this might disadvantage the firms that are being affected by these price increases.
Great. That was a great, straightforward introduction. It's funny because back in law school, when we were studying antitrust and begin to learn the very basic economic concepts of supply and demand, we learned that very intuitive logic that when supply decreases or when demand increases, prices will naturally rise. So when you're talking about a merger between two rivals, for instance, it's natural to evaluate market shares and consider that eliminating an independent supplier can lead to higher prices to consumer. But on the other hand, the logic is not that simple for many economic activities, especially when we're talking about B2B markets or intermediate markets, such as the relationship between health insurers and hospitals, licensors and licensees of intellectual property, content providers and distributors. And I think this is where bargaining leverage theory comes in, and also leads to my second question, because you were mentioning about vertical mergers. And is the bargaining leverage theory applicable to all kinds of mergers?
Yeah, I mean, in essence, the theory applies to all kinds of mergers, but mostly to vertical mergers, but to horizontal mergers as well. But the economic theory, for instance, has been showing us that the effects of theory differ substantially depending on the type of merger that you are facing and that you are analyzing.
I would ask you to elaborate further, and how can it apply differently to a vertical merger rather than a horizontal merger, for instance?
Take two examples. I mean, both of them in the hospital, on the healthcare industry, for instance. Well, the theory basically says that the expected margin-induced effects are context-dependent. So if you take the case, for instance, of vertical integration, a vertical merger between hospitals and insurers, okay, what the theory has been showing us is that such mergers are welfare reducing because they enable the integrated entity to exert disproportionate control over pricing and access. And this is basically due to two different demand steering incentives that play a key role in distorting prices. On the one hand, if you think that there is integration between hospital and insurance, an hospital and an insurance company, and they live in the market side by side with unintegrated firms on both levels of the value chain, what happens is that, for instance, the integrated insurer has incentives to negotiate more harshly with third-party hospital, because by so doing, it knows that it steers some of the consumers towards the integrated hospital. By the same token, the integrated hospital has incentives to negotiate higher prices with third-party insurers, because it knows that by so doing, it diverts consumers again from independent insurers to the integrated one. And this basically creates an effect which works against the consumer interests. But on the other side of the spectrum, if you consider, for instance, an horizontal merger, there is, for instance, a recent paper in the Journal of Health Economics by Marrey and Filho that shows that horizontal mergers involving insurance companies alone, enable the merged entity to basically increase bargaining power and negotiate better hospital tariffs for the customers, potentially increasing consumer surplus and general public health. And this is because there are two effects at play. I mean, if you have more concentration on the insurance market, basically what happens is that it's likely that one should expect that concentration should lead to increased market power in the markets where the insurance is sold, likely resulting in relatively higher premiums. But on the other hand, since the merged entity gains some scale of operation, it will be able to engage in stronger bilateral bargaining over transaction prices with its suppliers, with its providers. And this is one of the key drivers of insurer costs, and enables them to negotiate lower provider prices, which may then be partly passed on to the purchasers in terms of lower premiums. And what basically the literature has shown is that the second effect might then more than compensate for the first one. So you have a completely different outcome when you apply the same theory to an horizontal merger vis-a-vis what happens when you apply it to a vertical one.
Yeah, that makes a lot of sense. Yeah, it was interesting to hear a perspective on giving this example of different insurers coming together in a horizontal case, because when we're thinking about hospital mergers, which are very common in Brazil, for instance, I see the potential bargaining change through the perspective of an insurance, for instance, that wants to have a better bundle of products with more hospitals in the bundle that is offered to consumers, for instance, and how a merger could, in theory, reduce the set of hospital offers. For vertical mergers, such as, for instance, a media merger between a content provider and a distributor, it does seem like a whole different logic, because post-merger we have this newly integrated entity that has a bargaining change through the perspective of the downstream distributor rivals. As higher input prices to downstream rivals can actually result in greater sales that are diverted to the newly downstream integrated unit. It's an interesting theory of harm, and one that I must say I'm skeptical about sometimes, and must be applied with a lot of care, because I often get the impression that vertical mergers are very often beneficial to consumers. But in practical terms, and hearing you speak, what would you say are some of the key challenges or limitations of applying the bargaining leverage theory to merger analysis, for instance, in terms of data availability or metrics for measurement?
Well, I mean, the data availability is certainly a key challenge, and having the correct data to accurately assess the bargaining power of a merging firm and the counterparts is very important, and requires detailed information on several dimensions, for instance, on market structure and market shares, concentration levels, the eventual presence of countervailing power. But gathering such data can be very difficult, at least for two reasons. On the one hand, you might be facing information asymmetries between the parties involved, and some industries often even have complex supply chains. And on the other hand, confidential agreements might be in place, and this might limit your access to relevant data in order to perform your evaluation and assessment. Well, but even if data is available, as you said, I mean, measurement issues are also key because accurately measuring bargaining power can be very difficult. Why is that? I mean, think, for instance, about traditional measures of concentration like the HHI index, the Ishvan-Erfindal index. This may not be sufficient to capture the detailed nuances of bargaining power. For example, I mean, measuring the strengths of relationship between firms and their customers and suppliers requires information on the presence of long-term contracts, for instance. Whether you are facing switching costs or not when you think about changing provider. Then if you focus, for instance, on a relationship between producers and distributors, which is often the case in vertical mergers. Often happens that distributors, apart from distributing the products of producers, they have their own products, which are usually called private labels. And if this is the case, then this gives them some countervailing power and at least some outside option that they can use when negotiating the commercial conditions with the supplier. So these are clearly issues at stake. Another issue, which for me is a typical problem or a typical difficulty in merger analysis, but which applies here as well, is the difficulty in defining the counterfactual scenario. Why is that? Because, I mean, when you face a merger and you have to assess it, basically you have to understand what would have happened in case the merger did not go. Well, this is usually a problem because you have to predict a market scenario which is not an effective one, is one that would have happened in case the merger is blocked or was blocked. But I mean, if you, on the top of the usual problems, you introduce the dimension of trying to understand how bargaining power would have evolved differently under different circumstances, well, the scenario becomes even more intricate and delicate. So these are, in my view, the main three challenges that you face when you apply the theory.
That makes complete sense. And a follow-up question that purely made from a lawyer, and we don't have to get too much into mathematics, but how do we really? Because intuitively, I always thought that it's hard to get the right measurement and the right data for applying the bargaining leverage theory, precisely because in my perception, there are so many subjective elements, such as, like you said, the countervailing power of integrated companies that have white label products that also produce content. How do you put a number to that? I mean, how can we do it?
Well, I mean, the way you usually do it is by using econometric techniques. And one of the most well-known econometric technique is merger simulation. And when you use merger simulation, basically what you try to do is to basically model the supply side of the market and the demand side of the market. So on the demand side of the market, you tend to try to estimate demand, to understand how do consumers react to changes in prices, basically their price sensitivity. And the difficulty that you are mentioning comes on the supply side of the market, because when you go to the supply side of the market, basically you have to understand what are the specific details of the market structure in which firms are operating. And then you have to characterize all the relevant assumptions in the market. You have to design what we economists call a structural model, which is based on assumptions. And these assumptions include stuff like, are they competing in prices or quantities? Is the product differentiated or homogeneous? And you can, in these kind of models, introduce as well a dimension which basically represents the way in which firms negotiate, and what are their outside options when they are negotiating, which are the relevant strategic variables on which they are discussing the value. So this is all done within the modeling of the supply side of the market. And basically by interacting demand and supply side of the market, then basically you understand what is the jump or the change in the market equilibrium before and after the merger, or what is the change which is due to the merger. Basically, you don't attach a number, you have to attach many you have to basically attach many numbers and to rely on several assumptions in order to characterize in detail the context in which you are working in.
So it sounds like some of the other economic tools and analyses, which we'll be talking about in this Mergernomics series, feed into the bargaining leverage analysis that you do.
Indeed, or I mean, either they feed into or they are complemented by, in a sense, right? So because I mean, there are many techniques that we already use, like diversion ratios, for instance. Well, diversion ratios basically they estimate the percentage of consumers that switch from one product to the other if there is a price change, okay, due to the merger, for instance. But these diversion ratios they focus on consumer behavior. Okay, on the demand side of the market. So the BLT, the bargaining leverage theory, what they can do is to provide insights on how changes in the market structure resulting from the merger might affect the bargaining power of firms over customers and suppliers. So basically, it's a complementary dimension that you use on the top of the tools that you have used so far, that you are used to integrate in your toolkit.
Great, that makes a lot of sense, and I'm grateful to have economic experts to help us navigate those economic tools. I'd like to turn a little bit to the application of the bargaining leverage theory in real cases. Mm-hmm. We have seen recently bargaining playing a very central role in a number of high-profile merger cases. The first that comes to mind maybe is AT&T's acquisition of Time Warner. Mm-hmm. This case brought a lot of media attention because it was the first time in decades that a purely vertical merger was actually litigated by the DOJ, and also because DOJ heavily based its theory of harm on a bargaining model. So could you please comment a little bit on that case and how the bargaining leverage theory played a role?
Sure. Well, this is a landmark case and a very interesting one as well. What you have here basically is a vertical merger between two companies. So the AT&T is, as we all know, is a U.S. telecommunications company, the largest pay TV provider. Time Warner is focused its business on media, as you said, on content, and basically the DOJ was very concerned with the acquisition because it thought that it would substantially lessen competition. And this would result in higher prices and less innovation. That was basically the main concern behind. In particular, the DOJ claimed that the combined company would have the incentive and ability to hinder AT&T's rivals by forcing them to pay more for the right to distribute through Warner's networks. Okay. And basically, replying to your question, like the DOJ proposed to estimate the price increase imposed by the merger due to bargaining leverage using Nash bargaining model, which is one of the economic models that is most used in this settings between programmers and distributors. Okay. The interesting thing is that the court analyzed the case and considered that the choice of the Nash bargaining model was well-founded and in line with market reality. So basically, this was a validation of the analysis, the empirical analysis, and the economic analysis DOJ. However, the interesting bit of this case for me is that the court considered that simply showing that the prices would increase was not enough. This was not sufficient. Okay. And the judge, in particular, required the DOJ to show that the price increase to customers of AT&T's rivals was greater than the price decrease resulting from the elimination of double marginalization, which is an efficiency usually claimed in all vertical mergers. So the interesting bit of this, the interesting takeaway for me of this case is the fact that the court validated the application of the instrument, the technique, but basically said, I'm interested in understanding what's the net effect. I want to understand in this case whether the net effect is positive or negative for consumers. This is what I think makes this case fascinating.
I agree, and it's good that we actually saw the court doing an actual trade-off between the benefits of a vertical merger and the potential threats through the application of the bargaining leverage theory. Because in the end, that's it. You cannot block a merger even if the net effects are zero, right? You really would have to show real harm to competition. But it's interesting because I was when I was reading this case again, I understand it also from what you said that DOJ's model included this upstream bargaining model that predicted how the merger would affect the prices on the content sold by Time Warner to rival distributors. And that was all over the media also because Time Warner included very relevant content such as HBO, CNN, and Warner Bros. That, according to the DOJ, was very highly valued by distributors. But at that time, we were already living the rise of vertically related video content services that would offer content by subscription on demand directly to consumers like Netflix, Amazon Prime, Hulu, and so many others that really today we see that provided a whole new color to the actual importance of incumbent content provider. So that in theory could have an actual consequence on the bargaining leverage that AT&T would in theory have over its downstream rivals when negotiating Time Warner's content.
Indeed.
So do you think that when applying the bargaining leverage theory, the DOJ may have overlooked the specific characteristics of that industry as a rapidly evolving industry? Or more generally, I think what I'm trying to ask is if we take into account the potential competition, including competition with new content, new technology, how can this be brought or taken into account into a bargaining model?
Right. I have exactly the same feeling. I think this issue was highly overlooked. And in general, I mean, what I'm going to say applies not only to this case, but more general, as you said, to the application of this instrument. What I think is important when you apply the theory is to try and understand what are the outside options of the parties involved in the negotiation. Okay? And I have the feeling that in this case, the DOJ was basically assuming that, or considering, or at least presuming, that the content provided by the merged entity would be must-have content. While this is not completely clear to me, because as you said, there are many other alternatives, alternative providers and even alternative technologies that should be taken into account and included in the equation when you are basically trying to understand what's the relative strength of each party in the negotiation process. So, as I said before, that designing counterfactual scenarios is very difficult. What I would like to say here is basically designing or understanding or studying, assessing what is really the outside option of each firm involved in a negotiation process is the key aspect of applying this.
Great, that makes a lot of sense. So maybe we should discuss some other cases because it comes to my mind. The Fresenius NxStage case that was a bit after the AT&T Time Warner in 2019, which was the merger of healthcare provider Fresenius and home dialysis equipment NxStage. It was interesting because this merger had both a horizontal and a vertical component. So how would you say that the bargaining leverage theory applied differently or not to this case?
Well, in this case, the theory was applied to the vertical dimension, to the vertical theory of harm. And maybe I will focus on that only because this is for me the most interesting part of the case. And the theory of harm on that specific dimension was that the FTC considered that considered the input foreclosure or raising rivals cost theory of harm. And by so doing, it found that the totality of the evidence did not support the finding that such strategy would be employed. And basically, the evidence on market participants suggested that the merged company would continue to sell NxStage's machines to competitors of Fresenius. Okay. However, the interesting bit of this case for me is that the FTC claims that one adverse effect of the operation was the potentially increased bargaining power of the main co-buyer in the downstream market, which was called Davita. So basically, according to the FTC, Davita would enjoy the so-called pseudo-monopoly and power, in the sense that when negotiating with NxStage competitors in the upstream market, it would have a big word to say, in the sense that they would have a huge bargaining strength. They would be in a quasi-monopoly position. So for me, the main takeaways of this case are that this is a case whose novelty is that the main concern was that the vertical merger could potentially increase the bargaining power of the main co-buyer in the downstream markets. And this is key, because this is completely different from what we are used to see in merger investigations. And the implication for the FTC analysis was that this situation could, in their opinion, reduce the incentive of new entrants to make it to the upstream market, and thus restrict innovation. So basically, we are used to look at vertical mergers and apply the instrument to understand whether the integrated firm would indeed be in a better bargaining position to negotiate either with suppliers or with consumers. And in this case, basically, the operation was enhancing the bargaining power of an outsider in the downstream market. And that's why I think this is quite an interesting case, and with a novel theory of harm.
Indeed, definitely. And they're both very different cases, and also illustrate how the bargaining leverage theory applies differently in different contexts, exactly. Even though we were discussing two vertical cases, right? Would you say that the competition authorities in general are apply more often that to vertical cases, or do you see horizontal cases such as the hospital mergers applying that as well?
Well, I would say that from my experience, most of the cases I see the theory applied to vertical mergers from time to time, at least in a formal way. The instrument applied formally. You see it sometimes as well in horizontal mergers when countervailing power, for instance, is discussed, but not so often. So I think the natural field of application of the theory is clearly the vertical mergers one.
Yeah, I agree, because I think it's more in the sense maybe when analyzing monopoly power, as simple as that, because bargaining is also a form of competition. So when we have two hospitals merging, well, it does have an increased bargaining leverage over negotiation with insurers, for instance. But I agree, and it's the same in Brazil. I don't see that formally being applied to horizontal cases that often.
Well, I must say, however, I mean, that if you contrast the US experience with Europe, is a bit different. The experience, I mean, my impression is that exactly there is a significant difference between the US and Europe, and it lies in the historical treatment of vertical mergers, because while the US traditionally focused more on horizontal mergers, Europe has long scrutinized both horizontal and vertical mergers with equal attention. And that's why, I mean, I've been seeing the instruments being applied either for horizontal and for vertical operations alike, even though, as I said, formally more in the vertical case.
Picking up on that a little bit, how would you say that bargaining leverage theory is assessed in terms of antitrust policy in the US or in the EC? How has it been, for instance, or should be treated under merger guidelines, for instance?
Well, I mean, in the US, the 2020 vertical merger guidelines, which were issued by the DOJ and the FTC, they provide detailed guidance on the application of the theory to vertical mergers. And they emphasize considerations such as the ability to raise rival costs, or to foreclose competitors, or arm downstream rivals through increased bargaining power. In Europe, well, the angle is, I mean, is similar, but with some differences, because the merger control in Europe focuses more on preventing the creation or strengthening of dominant positions that could harm competition. And this includes the exercise of bargaining power. So I would say that in the US, after the guidelines, there was an explicit consideration of the application of the instrument, while in Europe, it seems to me that the instrument is more embedded in a more general analysis of the impact of the merger on the level of competition in the market.
But as far as I understand, we still don't have that much detailed or clear guidelines on, for instance, how we should apply formulas to apply the bargaining leverage theory. It's more of a hypothetical.
It's more
provision, right?
It's more hypothetical. You have some guidance, but not very detailed guidance. Yes, I agree.
So to wrap up, Hélder, how do you anticipate the bargaining leverage theory's role or relevance in competition policy to change or evolve in the future, especially in very dynamic sectors like healthcare and digital tech sectors?
Well, I mean, as a general message, I would say that antitrust authorities will need to continuously refine their understanding of bargaining dynamics. And overall, bargaining leverage theory is likely to remain a central concept in competition policy, particularly in the sectors that you have just mentioned. In terms of role and relevance and how the theory is likely to evolve, I would probably emphasize 2 or 3 factors. Well, the first thing I would like to say is that I expect greater emphasis on vertical integration. I mean, with the rise of digital platforms and ecosystem, vertical integration across different stages of the supply chain is becoming more prevalent. So, I mean, in my opinion, the bargaining leverage theory will play a crucial role in assessing the competitive effect of vertical mergers and acquisitions. So the theory is here to stay and continue. That's basically what I'm trying to say. The second note, which I think I would like to highlight, is that I would expect to see an increasing focus on data as a source of bargaining power. I mean, authorities must increasingly consider the role of data in shaping bargaining dynamics and assess whether mergers or conduct practices lead to the accumulation or abuse of data-driven bargaining power. I mean, we have seen the digital platforms growing everywhere in very different markets, sometimes creating new markets, sometimes completely challenging existing markets. And it's clear that, I mean, nowadays, having data about your users confers some power, at least some bargaining power. And it's basically key in the design of your business model. The third note I would like to leave on this is that, I mean, is related to what we discussed before. I would expect to see a growing need for international coordination and harmonization. As digital markets become more globalized, competition authorities will need to coordinate and harmonize their approach. I mean, we have just discussed the convergence of the approach regarding the application of theory in the US and in Europe. And so in my view, I think the theory, bargaining leverage theory, can serve basically as a common analytical framework for assessing competition concerns related to vertical integration. So these are like the three topics I would like to underline regarding the evolution of the application of theory to competition policy.
Paula, this has been great. Bargaining leverage is one of those terms that intuitively makes sense, that with greater market power, you would have greater leverage, but seeing how it's actually applied in antitrust analysis and the different outcomes you can get, and especially this comparison you did between DOJ, CAGE, DG Comp, and the different emphases, I thought was really illuminating. And Hélder, what you were talking about, future focus on data, I mean, if you think about how some of these digital firms have evolved from giving away content for free and monetizing by selling ads to now realizing that, oh, wait, the content itself can be used to train AI models. The content itself is now the monetizable product. I think you're absolutely right that these models are evolving and you have to take into account what do you actually have that can create a source of leverage.
I agree. I mean, I fully agree. I mean, if you think about it carefully, you clearly see that these digital platforms basically are two-sided markets, and basically they put in content they put in contact users on the one side and advertisers on the other side. So since they can monetize user data by selling sometimes profiles of consumers to the advertisers, they many times are able to basically provide services for free. So as Margaret Veiga said, the commissioner a few years ago, data is the new currency. So basically, data is being used in order to, as an input, basically, in order to produce an output which is valuable for advertisers. And by so doing, they are able to provide services for free on the other side of the market. So in the end, I think this is a win-win strategy for all the users and all the stakeholders involved in the process.
We like to end these shows with some takeaways for practitioners. Hélder, what would you say are the key takeaways here?
Very good. I mean, I would probably highlight 3 takeaways. The first one, from what we discussed so far, is that bargaining leverage induced effects on welfare, and especially on consumer welfare, which in the end of the day is the main concern of the antitrust authorities, is the context dependence. Okay, so as the economic literature has shown recently, the type of merger at stake does matter when one assesses those effects. So context matters. I would say it's the first takeaway. The second takeaway for me is that in the context of vertical mergers, there is a clear trade-off between potential harm to competition resulting from bargaining leverage on the one hand, versus potential efficiencies being eventually passed on to consumers on the other hand. And the AT&T with Time Warner is a good illustrative example of this point. And I think the court was very much right when it basically required that the net effect should be discussed. What's the net effect of the practice on the welfare of consumers? And the third note I would like to leave is that the rapid pace of technological innovation and changing market structures will continue to challenge traditional approaches to competition policy. So bargaining leverage theory clearly plays an important role in the process of understanding the full spectrum of merger. These are my takeaways.
Thank you, Paula. Thank you, Hélder. This has been really illuminating glimpse into how bargaining leverage theory works. Paula, I'm looking forward to future episodes of this Mergernomics series with your committee. I think it's been really educational for our listeners. Any final words for our Spanish-speaking and Portuguese-speaking audiences from either of you?
Obrigado aos nossos ouvintes no Brasil. Foi um prazer estar aqui discutindo a teoria da barganha. E vamos ficar aí junto para os próximos episódios.
Obrigado também da minha parte. Espero que o episódio tenha sido interessante.
And we'll see you next time on Trust and Trade.